I would like to touch upon a few points that promoters must keep in mind as they go about planning an IPO. The first point relates to estate planning. An estate planning exercise that necessarily involves establishment of a family trust must be completed prior to filing the draft red herring prospectus with SEBI. The establishment of a family trust prior to an IPO will involve transfer of the promoter's shares, some or all of it, into a family trust which has been set up for the purposes of succession planning. What one has to keep in mind is that there are certain eligibility requirements under SEBI regulations which have to be kept in mind before such shares are transferred to the trust. These requirements relate to eligibility of shares that a promoter must hold and lock in at the time of the IPO. From that perspective, the advisors and other legal counsels will have to analyze, along with the promoter, the shares that can be moved to a family trust for purposes of a succession planning exercise. The second point is in relation to special rights. The Indian regulators, SEBI and the stock exchanges typically do not permit special rights to survive post-IPO. Accordingly, any rights that the promoter may have in a pre-IPO company, which relate to board seats, operation of the business, will have to be terminated at the time of listing. Accordingly, any arrangements that the promoters and investors with the company which relate to such special rights will have to be carefully analyzed, reviewed, and accordingly necessary steps have to be taken such that these rights do not survive post-IPO, and any impact of such rights falling away on IPO on the promoter's holdings and board composition will have to be carefully reviewed. The final point that a promoter must keep in mind is in relation to the composition of the board, which necessarily takes some amount of time to reconstitute, as that is required under the SEBI listing regulations to comply with a listed company's board requirements. Stake monetization, if there are any shares that the promoter wishes to sell in the IPO, that also has certain regulatory requirements around it which have to be carefully reviewed, particularly in conjunction with the estate planning exercise. And finally, the use of proceeds that the company wishes to raise from the IPO will also have to be carefully debated and reviewed for a successful IPO. Thank you.